Hello, everybody. I am Erica D'Angelo, and I thank you for joining me today. Today, we're going to be talking about marketing and SEO contracts. As business owners, this is something almost all of us will have to enter into. We'll probably all have a website, and we probably have some sort of marketing efforts at some point in time. And this is also relevant to people who are in the marketing industry, whether they're a marketing agency or a freelancer. These are all things that they need to know as well. And I want to talk about this today because so many people are having issues with their marketing agencies and SEO companies. I've been there too myself multiple times. It is not fun. And it's really hard when you're trying to run a business and you're trying to make your name available to the general public and you want to bring in revenue to really find the right company and be able to trust them. So there's a few legal considerations that can help you with this process, and that's what we're going to cover today. So first, let's talk about avoiding that from happening. I mean, I know that sometimes it's too late. You find out too far down the road, or you're giving them a chance because things take time, right? I understand that. So we'll touch on that as well, about what to do if you get into that situation. But first, I'm going to talk about what to look for. And contracts are not supposed to be scary. Contracts are really a good thing. They're good for both parties involved. That's because a contract tells you and the other person what their obligations are. What are their responsibilities? What do they do if they change their mind or they want to get out of the contract? How does that look? What happens if one side doesn't pay? And you should know, as the person paying too, what happens if you don't pay, right? So it really just puts everybody on the same page and should be a fair agreement where both sides feel comfortable. If both sides don't feel comfortable with the terms of the contract, you shouldn't be entering into the contract to begin with. Now, I'll say there's exceptions with stuff like cell phone companies and things that are kind of essential where we don't really have leeway with playing around with the contract and we kind of just do it to do it, right? Because we feel like we have to. That's not what I'm talking about here, though. I'm talking about a contract with a web designer, a marketing company, SEO, whatever, where you do have that choice. You have the choice of who you want to hire, and you have the choice of the contract that you enter into. So that said, the first thing is that it should be beneficial for both sides. All right. So now, if you're the marketing company, here's a few things that you'll want your contract to contain. Payment terms, right? How frequently are you paying? Is it a set rate, a flat rate? Is it based on an hourly spend? Is it, what happens if somebody doesn't pay too, right? Like, do they become immediately due for the remainder of the month, or is interest starting to accrue? When does interest start to accrue? How much does it accrue? Are there exceptions to this? Are there reasons that are acceptable for late payment? What happens if there's a dispute? Like, all of these things are important and they're beneficial for both parties involved, but especially in this particular instance for the marketing company themselves, or SEO or web design. I'm kind of using these terms interchangeably. A lot of companies provide all of these services, but even if it's a niche company just providing one or some of these services, I'm still referring to those companies. All right. Another thing that should be contained, and this is important for both the web designer company and the purchaser, the business owner who's purchasing the marketing web design services. You want to have a clear scope of work in there and what qualifies as complete. What level of quality is sufficient for them to meet their obligation under the contract. If the definition is, okay, we'll post on social media for you 2 to 3 times a week, and they're just posting generic content that has nothing to do with your business, or that's not really doing anything to create value for your company, is that sufficient? Well, maybe if the scope of work just says we'll post 2 or 3 times a week from your Facebook account, and that's what they do, well, then maybe they kept up their end of the bargain, right? So you want to be really clear about what it is they're going to be providing and what time frame. Okay, if they're going to be doing a website for you, do they have to get the rough draft to you within a month? The first draft for you to review and approve and say, yes, I want this to go live or not? Or do they have an indefinite amount of time? They could be just working on this for months or a year and, say, well, we're still working on it. We have something in the works. And meanwhile, you're still under contract and obligated with them, and you don't have a website generating money for you. So that needs to be really clear. And it's important, obviously, from the consumer standpoint, the business owner who's hiring the marketing company, but it's important for the marketing company too, because in any business, there's bad customers. There's people who are just not going to be satisfied and not being happy. And you have to make sure that you're protected as the marketing company too, where you're not just going to sit there and do unlimited revisions and never be able to appease them. So at what point is your job done? And of course, you always have the interest of making them happy too, but at some point you're going to say, look, here's our agreement. We've already done our revisions. We've already done whatever, the case may be. And we're just not going to do it anymore. And maybe you don't want that person as a client, right? Which leads us to the next thing that you should have in the contract. And this is, again, applicable for both the benefit of the marketing company and the benefit of the consumer, the business owner. And that is the termination clause. Like, how do you get out of this agreement? Maybe either party is not happy. Maybe as a consumer, you're like, you know what, they're doing their job, but this is just not my style of marketing. I just don't like the way that they're doing it. Or maybe you decide to get to a point where you're like, I'm just going to bring somebody in-house to handle all my marketing. I don't want to deal with this marketing company anymore. Okay, there's a bunch of reasons why you might want out of the contract that aren't necessarily negative, not necessarily like, oh my gosh, this marketing company is screwing me. So you want to know what that looks like. How do you get out? A lot of times they'll have like a 30-day notice provision. So you give them 30-day notice. They'll continue the rest of the month, especially if it's a month to month. They'll continue out the work that they were obligated to do, or you can tell them to stop, but they still get paid. And then you move on to whatever you're doing instead, or maybe you're not doing anything. But regardless, you need to know how to get out and how to get out appropriately so you're not accidentally owing more money than you anticipated. What if it's a 60-day notice? Now you have to prepare 60 days ahead of time that you're still going to pay for those 2 months, even if you don't want to be using those services. And that doesn't make it a bad contract, but you need to know that ahead of time so you can anticipate how you want to react in the future, okay? And especially if this is a high dollar amount contract where you're paying like a high monthly payment, yeah, you want to know that. You want to know that no matter what happens, you need that 60 days worth of payment to get out, assuming nothing crazy happens and they're not trying to screw you over, completely not delivering, right? So that's also important conversely, right? Because what if the marketing company wants out? What if they just think that you're a difficult client or you just don't align with what kind of clients they want to handle right now? Maybe they're going niche and they're only handling like trades clients, who knows? There's a million reasons why people want out of contract, but make the terms of termination clear so everybody knows how to get out and what to expect if that happens. And importantly for owners of marketing agencies here or web designers, there has to be some sort of transition period too, where you hand back all of the passwords or access to, Google My Business, Facebook, whatever internet accounts or even your domains that they're using. There has to be a transfer period so that you can give it back to the client and so they can continue maintaining it themselves or pass it on to whoever is going to be handling their marketing in the future. And that's really important. You don't get to just drop the ball. You don't just say, I quit, and not help the client get their stuff back, right? Or that's going to be a whole nother conflict, potential lawsuit. You just don't want to go down that path. Now, for business owners specifically, I would say this is a benefit to both, but more importantly, if you are hiring a web design company, a social media management company, or anybody who's going to create any content for you, blogs, whatever, you absolutely need to make sure you have an intellectual property clause in there that gives you ownership of the materials, okay? Because if they're creating a website for you and they're putting all this blogs on there, they're making graphics, whatever they're making, they own it unless you have this clause, unless you have an agreement that says they're making it for you specifically, okay? Now, that's important because if and when your relationship ceases, which is, you know, pretty positively going to happen at some point. Your business is either going to outgrow them or you're going to change paths or something. You want to make sure you still own all your content. I mean, that is the value here, right? If you're doing online marketing and you're listening to this video right now, you probably understand the importance of your content, especially online. So you want to absolutely make sure you own it. And if that clause isn't in there before you enter into an agreement with somebody who's going to be creating stuff for you, do not sign it and do not pay them until you have an agreement that you're going to be able to own the content. Okay, I can't stress that enough. That is one of the most important takeaways from this video. All right. And here's another one for you guys. If you are hiring an SEO company, search engine optimization, be careful. And I hate to say it because there's so many great companies out there that can help you with your SEO. But there are so many who are just preying on your ignorance and your lack of knowledge in the industry. And I've been a victim to it myself. Thankfully, I have the tools to take care of that as a lawyer. But what they do is they promise you all these things and they do just these little tweaks and say, okay, yeah, we're gonna raise your SEO ranking, or we're gonna create this landing page and get you to the first or second page on Google or whatever they promise you. But the thing is, that's not going to give you the long-term SEO results that you're probably looking for. So I say define what SEO is. If they just put in their scope of work, website development, social media management, and search engine optimization, that doesn't tell you enough information. You need to know what they're doing for the search engine optimization. So if and when you don't see results after 3 months or 6 months or however many months they say you need to pay before you start seeing results, you can then say, well, what did you actually do? And they might just say, well, we went in, did your profile on Yelp and whatever other services there are out there these days, Google My Business. I don't know, there's so many search engines and in different directories and stuff where you can find businesses. And so they might go in there and make some changes and they might do some things, but that's not what's really going to establish your SEO. And I'm not claiming to be an SEO expert by any means, but it needs to be defined what they're doing that you're paying for when they call it search engine optimization or SEO services. You need to make that clear, okay? All right, so I know that was a lot, and that certainly doesn't encompass everything that should be in a contract between a business owner and a marketing company, a web design company, SEO company, whatever it is. It does not encompass all of the terms, but those are just some key terms that you guys should be thinking about, you should be looking for in your contract. And the fact that if there's not a contract, that's a red flag, all right? Step number 1, red flag, need a contract. And it doesn't mean they're a bad company or they're going to screw you over just because they don't have a contract, but either way, you need to protect yourself. If they don't have one, you need to get one. Get with a lawyer who knows that industry and what needs to be in the contract. And then, maybe hint, hint, marketing company, you should probably get a contract too. That's beneficial to both sides. All right. So now we talked about what to look for when you're going into contract, but a lot of you probably already have contracts in place with web design companies, or you at least have hired a web designer or marketing company or something of that nature. So if you have one and you want out, there are some ways. Now, if there's a good company and you had the contract and it has a termination clause, use the termination clause. But if they did something else and they breached the contract, or they're, quote unquote, screwing you over, well, okay, then that's a problem, right? So here we go. First of all, did you breach the contract? Did you just stop paying and not tell them, and you're wondering why they're upset? I mean, that could be a real thing, and they might have grounds to say, no, you need to keep paying, even if you weren't happy with their services. So you need to make sure that you're doing that right. Now, there's some reasons why contracts could be not valid. And I didn't say invalid because when it comes to contracts, there's so many terminology that's nuanced. There's void, voidable, unenforceable, all these things, and they mean slightly different things from a legal perspective. And of course, this is only meant for your education. This isn't meant to be, one-on-one legal advice, but I still don't want to confuse you guys if you guys go back to Google and you start putting in these search terms and, getting confused by all terminology, all right? So they all have subtle differences, but there's a few reasons that qualify for you to get out of a contract, okay? One of them would be if the other party materially breached the contract. And that's hard to define sometimes if it's not specifically said in contract that this is a material term or doing this is a material breach, which should be in the contract as well. But if it's not, and oftentimes it's not, you have to then say, think analytically, what would be a material breach? So if you're in a contract with a web designer and they're supposed to make you a website within 3 months, and on the third month they give you a web design, it's not live yet, but they send you over the mock up, whatever. I don't even know what the terminology is here, but that's not important. So they send it to you, but you don't like it. You're like, you know what? That doesn't go along with my brand. I don't like the content on XYZ service pages, whatever. Well, that doesn't mean that they breached the contract. They got you a website within 3 months, and presumably it met the terms of your agreement. But now, let's say it's 3 months and 2 weeks, and they haven't provided anything to you. Did they materially breach the contract? Maybe. I mean, you said you needed it within 3 months. They were going to deliver it within 3 months. Now you have nothing. But is that a material breach? I mean, the biggest, most important part of the contract is obviously the website, right? That's what you hired them for. You paid them for. That's your biggest obligation, and you got nothing. But does not having it 2 weeks after the deadline make it a material breach, or should they have time to, cure or get you your website? And that's a gray area, right? If you don't have that in the definitions of your contract, that's an argument. So, most likely I would say it's not a material breach yet. But if 4 or 5 months rolls around and you still don't have anything, and you gave them 3 months, I mean, I would say that's almost certainly a material breach, especially because the damage each month that goes by is doing, right? If you committed to 3 months to get your business up and running, you knew that you were going to be ready to sell, and then you have 2 months where you don't even have a website. How are you going to be marketing your services? How are you going to be selling your products? Or, whatever the case may be for you. So I would say in that case, yeah, that's a material breach, right? Especially if that was part of the contract or the conversation. Of course, yeah, you need your website ready to go. So if they do a material breach, that's a way to get out. A material breach, conversely, if you're the web design company, is if they don't pay, right? I mean, these are the two biggest components to the contract. That's what makes them material. But again, there's just so many gray areas. That's why it's important to define what terms are material, okay? So that could be one way out. Now, if they promised you all these things and they made these misrepresentations to get you into the agreement, well, that could also be grounds for getting out of the contract. Like if they say, we guarantee that we're going to get you on the front page of Google for X and Y search terms within 4 months, and 4 months rolls by and you're not on the front page of Google for those search terms, well, that sounds pretty misleading. Now they might have a little clause in there that says, oh, cannot guarantee results, or who knows, right? Like there's so many tactics in here. There's so many shady companies out there, especially in an industry like this where it's not very regulated. Like us as attorneys, we have ethical obligations. We have a bar that, governs our license. If we do something wrong, they're going to punish us, where marketing companies and things like that aren't really regulated. So there's a lot of sketchiness out there, especially in this world where it's so in demand, So I'll just say be careful careful about that. But it is potential grounds to get out of the contract if they, make misrepresentations or false promises or anything along those lines. Something else is sometimes the signatures are wrong, or the person who signed it didn't have authority to sign it. So that can be grounds to get out of a contract too. Now, that doesn't mean that if you go to court and the judge is like, oh, you had your husband sign on behalf of you, this contract is totally void and I'm not going to enforce any terms of it, because you can also have like an implied contract, right? So you still communicated with that marketing company, you still told them that you wanted the services, all these things that you agreed upon anyway that were memorialized in this contract might still be valid, but maybe the contract itself isn't valid, and so certain terms of that agreement aren't. And that can happen in both directions. So if you have your spouse sign on your behalf and it's not valid because maybe it's for your business, they don't have any ownership interest in the business, or maybe it's in your own name, right? And they can't sign on your behalf. That's invalid. But also if you're using maybe a smaller marketing agency and they have the wrong business entity on there, or they have somebody's signature on there who does not have authority to bind that business, that is also a potential grounds for getting out of the contract. Maybe not out of paying or out of having some sort of agreement as a whole, but that could make the contract not valid. Okay, I'll be careful with these words. Basically void, but not valid. All right, so those are a few ways that you can potentially get out of a contract from a legal standpoint. Now, sometimes it comes down to just them doing a really crappy job, and they did my example from earlier where, they did post on social media 2 days per week as they agreed to, but it was just, maybe really crappy and maybe didn't have much to do with your brand. Maybe it was just, happy Groundhog's Day from XY business. And that's not really going to achieve what you want. But there are other methodologies if they won't cooperate. Hopefully everyone cooperates, you guys. Like, trying to work things out with each other is usually the best thing for your business. Disputes are not good. And sometimes it's hard for me to wrap my head around some of these companies where they'd rather jump through all these hoops to try to fight instead of just doing the right thing to begin with. But that's a part of business and a part of life. So if you have a difficult company who's not working with you and try to come to a compromise or a resolution, we have resources out there to help protect us as consumers. And you have the Better Business Bureau, you have reviews, which of course you have to be careful with. You don't want somebody else leaving you a bad review. Even though that would violate terms of service, it's still like for Google's terms of service or whatever. If you're not a customer, you can't just leave people bad reviews, okay? You don't have any affiliation to know about their services, but people still do it. So be careful with that. But there's also your credit card company. And if you're a business owner and you're not using a credit card, you're still using your debit card, that's a different problem, but you need to stop. You need to get a credit card. You need to use a credit card. It's really dangerous to be using a debit card as a business owner. Again, not my expertise, but talk to your banker. There are some things where if you don't catch fraud within 24 hours, or maybe 48, but I think 24 hours, you limit your recourse. You might not be able to get it back. So you just don't want to be messing with debit cards with your business account. But if you use a credit card, most business credit cards have built-in protections for stuff like this. So just by the same token, where if you order a pair of shoes off the internet and they never show up to your door, you can dispute that charge with your credit card company. You can do the same thing with services, right? Because you didn't receive the service. Just because they're out there and they have a website and they say that they provide marketing services or web design services doesn't mean that you received what you were promised and what you paid for with your credit card. So I have done this, and I would recommend doing this if they didn't do what they were supposed to do, okay? Again, there's a difference between them doing a crappy job and them not doing their job. So if they didn't actually do their job, like they were supposed to have a website, for you in 3 months and it's month 5 and you've already paid for the first 3 months, okay, well, I think that that's grounds for your credit card dispute. You didn't receive the services that you paid for. So I recommend disputing it that way. And I mean, it depends what's most important to you too. Like if you're just done and you want away from that company, great, get your money back so you can go get another website. But if you think that they're going to deliver a good product and you're okay waiting, well, then maybe you say, okay, never mind, credit card company, I received my product now or my services now, and I'm happy. I mean, that's, you know, a judgment call, it's a personal preference, it just depends on the situations. Now, chargebacks aren't a good thing. So it looks really bad on the company who you disputed. So again, you know, that depends on your level of patience with that company and how bad they've been. And if they really didn't provide you anything, well, I would say, you know, that's a judgment call on your part. If you want to get your money back, I say go for it, right? Now, that's all a bunch of practical tips. Really, that's not on much of the legal side, but whenever a situation like this arises, oh gosh, it's so frustrating for me as a lawyer. Well, and because it's funny, some of these companies actually target lawyers, and that blows my mind, but a lot of lawyers don't practice in the area of contracts. And just like all humans and business owners, some lawyers don't read every contract they enter. I mean, you should be reading contracts all day. Like, we buy things left and right and sign up for services and social media accounts and all things, right? So not every contract gets read. But I hope that these practical tips and the legal tips were helpful if you did get into a situation like that. But I'll say, just don't repeat the mistake if you've already gotten there. And if you already have a web design company and things are going smooth, but you don't have an IP assignment in there, it's not too late. You know, just go ahead and get the right contract in place, get the rest of the terms worked out, because just because something hasn't happened yet doesn't mean that it can't happen in the future. So, right, don't repeat your mistakes. Let's be preventative. And there's a couple more things that I want to talk about on the category of being preventative, and then I will move on. But that said, hey, you guys got social media accounts, got domain names, you have things that are important to your business, and you want to make sure that you get to keep them, and you want to make sure that the content connected with them is protected and that it's yours as well. So if you get into one of these disputes with one of these companies, maybe a bad one, and they try to hold your domain name hostage, your website hostage, or they try to keep your social media handles, I mean, you definitely have ways to get around that, especially if you own your trademark. You know, you have entitlement to your trademark on social media, you know, in most situations. I'm speaking generally here. And you can get those back, right? And these companies are just doing unlawful tactics to try to basically extort more money out of you, even though they weren't delivering what they promised. Same with your Google page. You know, you want to make sure that you have access to that back. Sometimes these companies, another red flag is when they ask you to like give up your complete control over your Google My Business page or certain pages. Like, you should always have administrative control, even if you have to let other people have access to manage it. Don't give it all up. And lastly, your domain name is so important. You guys, buy it, own it before you do pretty much anything. Before you even set up an LLC or corporation, buy your domain name. Before you file for your trademark, buy your domain name. And before you hire a web design company, buy your domain name, and do not give any sort of ownership of that domain name or exclusive access to the web design company, because you don't want to even have to worry about something happening where they're, you know, holding your domain name hostage. Maybe they own the rights to the website that they designed because you didn't have an IP assignment. Okay, but at least at the end of the day, if you have your domain name, you could build a new website. You might even lose all the SEO if there was real SEO associated with it, but at least you'll have the name. So those are a few more tips for being preventative and trying to avoid these worst case scenarios that happen every single day to business owners who are working with web designers, marketing agencies, SEO company, social media managers, all of these types of things. And I know we all just want to grow our business and we want to generate more revenue, but we have to take precautions and we have to be preventative. So you guys, if you have any questions about this, please don't hesitate to reach out, Erica@d'angelolaw.com. Thank you.